This is something that is completely ill-conceived. Actually, it is mischievous. And that is why even the Law Society itself has stepped down and has said this thing must be looked at very, very carefully, because otherwise we are precipitating a major constitutional crisis. We may not have a Supreme, we may not have a Supreme Court. And if there's the appointment of the ABC and there's no Supreme Court, and that one is also taken to court, and there is no, there is no Supreme Court, then it means that even the ABC itself will not be able to, be functional, and they will not have credibility. This move, is a very dangerous move. In our situation and in Africa generally, it is like the executive is senior, and the judiciary and the executive, the judiciary and the legislature, the legislature as well as the constitutional commissions and independent officers are supposed to be inferior, which is not the correct aspect. And that is why, for example, we will remember how Maraga in Bomas, there was a time he got a dress down. Even after Maraga was able to annul, the Maraga court annulled an election, presidential election, he was told that a time will come when there will be a revisit, of that matter. So we must also be alive to the fact that there's been that issue of the executive and the judiciary also being at loggerheads, and most of the time it is the judiciary, it is the executive which has got a problem when they are doing certain things, and the judiciary says that is not the correct thing to do, it's not constitutional, it is not according to the law. And when you look at a lot of the cases where, for example, the judiciary makes a decision and the executive does not obey court orders, and we have been treated to a lot of episodes of that kind, which in democracies, that is unheard of. You are not supposed to refuse to obey court orders, but we have had a long history of that, and even very, very recent. The police service and so on, people refusing to come to court and all that kind of stuff, and that becomes a very, very dangerous thing to do. So when there is also that history of the judiciary making certain decisions and the executive not wanting to pursue them, to follow them, then we can know there's a beef between those two sections, and especially the executive does not want to be held accountable through the judicial process. Actually, when one looks very, very carefully at the unfolding of devolution, if it was not for the judiciary, the devolution process would have had a lot of problems when, like, the executive was taking away, powers that belong to the counties, refusing to give functions, to the counties, to give money to do, things that should be done by the counties, and there was a lot of to and fro. The Council of Governors going to court on many times, particularly at the beginning of devolution, so that they could get the judiciary to protect devolution and particularly the counties. Even recently, everybody goes to court. Like the students have gone to court because of the university education, new model. During the finance laws, people go to court, particularly through Omtata, because again, there are untoward things that are happening without public participation, and so it is a fact that there are many occasions many times when citizens, when there's public interest litigation, and the judiciary makes decisions that the executive doesn't like. And again, therefore, that brings friction between the judiciary and the executive. I think something else that we need to appreciate is the judiciary does not make decisions without litigants. People have to go to court to ask the judiciary to resolve a dispute. So it is not like the judiciary is all over the place looking for cases to make the life of the executive or anybody else difficult. So when there are disputes, the judiciary must attend to them and must resolve them. So that is something else that I think we need to understand as citizens, that when you blame the judiciary, they work when you take disputes to them. And so it's our disputes as citizens. Even government takes, cases, to judiciary. So, there's that kind of context. Then I think we need also to know that Parliament itself was able to refuse to abide by when they were told that the gender rule, the 2/3 gender rule, that they are supposed to pass legislation to make the National Assembly and Senate make sure that there isn't more than 2/3 of either gender. But they refused to do so. And actually, according to the Constitution, eventually, the Chief Justice wrote to the President saying that these people require the Parliament now should be dissolved, and of course that has not been followed. So one again would ask, if Parliament as in its totality was not dissolved when the President was supposed to do that, so why do you want to dissolve the Supreme Court, the apex court, and actually essentially collapse the entire judicial system, so that it is not just the Supreme Court which is being attacked? When you attack the Supreme Court in its totality, for reasons that Ndegwa explained, that you remove it, it's not easy to replace it, it's not even easy to go through the tribunals, because there will be, when things go to court, to court, when they are challenged by those judges, you want to remove all of them, then it means that the Chief Justice, who is supposed to be the one in charge of the entire judicial system, there isn't the Chief Justice. So actually you are affecting, because the Supreme Court is the one which guides all of them, all the other levels. So it means that you are actually attacking the entire judiciary. And if you attack the whole judiciary, apart even from the presidential elections that was mentioned, meaning that even if if we have those elections, and if there is a dispute, as usually there is a dispute, then it means that the person who has decided they have won, and if they didn't win, it means that now they will sit comfortably, because there will be no Supreme Court to adjudicate on that matter. So that's another constitutional crisis. Then we need to appreciate that usually you take like a single person, like if two people were taken, if again as has happened in the past in the Court of Appeal, High Court, when you take several people that you really have a case for, then we can say this is genuine. But if you say that the entire Supreme Court is going to be removed and all of them are guilty, and they are guilty, whoever is trying to remove them, they are guilty, then that tells you that it means more than, it's not really something of trying to get the judiciary to be accountable, but this has got political undertones. And particularly if for a long time there is a move to discredit the Supreme Court first, so that eventually, as you bring some charges from wherever you get them from, then you have tried to influence the public until the public is saying, okay, maybe because there are these lawyers who are saying and others who are saying that these guys have done wrong things. Maybe it's true. So you can see that the Supreme Court is first of all being taken through the public court to prepare for now the legal stuff. But when you have genuine reasons, you proceed. You don't even prosecute the thing in the public domain before the Judicial Service Commission acts. So the moment you bring it into the public domain repeatedly and actually, call them names and say they have done whatever it is and all that kind of stuff, so that you want to convince the public that there's already wrongdoing. Then again, that clearly says that that clearly says that you are not doing, the correct thing. This is lynching, and this is politically motivated. So now, if like the bulk of the Judicial Service Commission is even if there are those others, there is the Attorney General, members of the Public Service Commission, then the two people who are non-lawyers. There is a problem because the guys who really know how how the Supreme Court, how the Judicial Service Commission is able to be the body that supervises the entire judiciary is the Chief Justice, the Supreme Court representative, the Court of Appeal representative, the High Court representative, the magistrate, and then of course the Chief Registrar, who is the Chief Registrar, who is the Secretary. So suppose those said this is not genuine and we don't want to participate. And because actually the Chief Justice, the representative of the Supreme Court, those two are supposed to be also part of the people who will go away. So the moment you do that, and those five plus the Chief Registrar, they say that they don't want to get involved, then it means that there will be no legitimacy for the Judicial Service Commission to do whatever it has to do, so that the president can go and appoint a tribunal. And if, for example, there was a tribunal appointed for the Chief Justice, and the Speaker is the chair, and the Speaker is politically aligned, then again, that will be a problem. So I think I have tried to really follow what Ndegwa said, to demonstrate that this is something that is completely ill-conceived. Actually, it is mischievous, and I have a lot of respect. I have a lot of respect myself for Hamid Nasir. I taught with him, and he was, a very good teacher. Even at below 30, was appointed as an acting dean, although the university didn't accept. But I have to say that now what is happening in this instance cannot be something that is being driven by the law, and that is why even the Law Society itself has stepped down and has said this thing must be looked at very, very carefully, because otherwise we are precipitating a major constitutional crisis. We may not have a Supreme, we may not have a Supreme Court, and if there's the appointment of the ABC and there's no Supreme Court, and that one is also taken to court, and there is no, there is no Supreme Court, then it means that even the ABC itself will not be able to, be functional, and they will not have credibility. And finally, as I learned, Redemptor, the moment it looks like you don't have a proper legal system, then business, and especially business from abroad, they'll be told that in that country there isn't proper rule of law, there isn't proper constitutionalism. So it's risky for you to invest there. And already, if people are going to other places because of, problems that we have, and then we have another problem of there isn't a judicial system, then we are playing with fire. And, one option, and I can now understand why the deputy president, Kindiki, it's not a tribal thing, but it is his understanding as a lawyer, as a human rights lawyer, understanding that this move, is a very dangerous move as far as, our country is concerned. And I think I need to land, but we hope that people involved, the sense will prevail, and this dangerous matter they will leave to do what they are trying to do. And I learned.